So I know we just had class exited. We'll have class coming back, but I want to go ahead and get started since we have limited time. Welcome to everybody here, to everybody watching the webinar online. My name is Deborah Pearlstein. I direct the program in law and public policy here at the School of Public and International Affairs at Princeton. I'm delighted to be here for what I expect will become an annual fixture of our program's programming for Constitution Day and its annual event. And that is a preview of the coming Supreme Court term, which begins, of course, the first Monday in October. I am especially thrilled to welcome a remarkable set of Supreme Court reporters and commentators to help us talk through what just happened in the term just passed and what is coming up ahead as the Supreme Court comes back into session at the height of what is already an eventful presidential election season. The panelists' full bios are online, but I want to just introduce them briefly here so we can get to the meat of the conversation. And I think I'll do roughly alphabetical order. Let me start with Jess Bravin, who's here to my right, who is the Supreme Court correspondent for the Wall Street Journal and who, among many other things, has written a terrific book about military commission trials that were stood up at Guantanamo Bay following the attacks of September 11th, which is worth reading under any circumstances. This is Jess Bravin. Josh Kaplan. At the far end there is a reporter for ProPublica, who is substantially responsible for a remarkable set of stories, for breaking a remarkable set of stories in the past year about the influence or involvement or relationship between Justice Clarence Thomas and a very wealthy benefactor named Harlan Crow. And his reporting helped put the court in something of an ethics spotlight, not a good one. We will talk more about that certainly over the course of our discussion. Adam Liptak here on my left is the Supreme Court correspondent for the New York Times, who has written also many wonderful things over the year. But I would be remiss if I did not note that on, was it Monday?
It was Sunday.
Sunday, okay, I'm sorry, very recently, came out along with his co-author Jodi Kantor with a wonderful must-read article on the front page of the New York Times that sheds some light inside the court in its reasoning surrounding some of the most consequential decisions of the past term. And I'm sure we will talk about that a little bit at a minimum as well. If you haven't seen that story, you really probably better Google that. And then, of course, Kate Shaw on the far side, who is a professor of law at the University of Pennsylvania Law School, where she teaches constitutional law and administrative law, among other things. But I think here on campus, and probably the reason for our overflow room and our enormous web presence, is perhaps better known here on campus as the co-host of the extraordinarily popular podcast Strict Scrutiny. And whether you are a podcast person or not, I really recommend tuning in for at least an episode. They have made the Supreme Court cool or something in a way I'm not sure it ever has been, but at a minimum, opining with enormous clarity and insight with her co-hosts. Okay, so I hope to keep this just the comfy chairs. I hope to keep this as conversational as possible. I should note, again, we have classes coming and going, so they will kick us out of the room at 1:15 or a little thereafter. So we'll do our best. But I want to start, Kate, if I can, with you by asking you a completely unfair question. And I can do that because I know you from before, but still, if you had to pick the most consequential decision of the past term, right, a term in which there were a lot of blockbusters, as they say, what's your pick and why? You don't have to write an essay.
This feels like I have actually on this case, but I won't deliver it here for all of you. But I think there's no question that it's the presidential immunity case, Trump versus United States. This was handed down on the last day of the term, July 1st. It involved, right, the charges brought by special counsel Jack Smith involving essentially a conspiracy to subvert the results of the 2020 election, culminating in, but not limited to, January 6th and the attack on the Capitol. So that's a decision that I continue to find totally stunning. In many ways, the more so, the more you read it. And I would say that I count myself a dissenter from the position that the opinion manages to, quote, soar above politics, persuade the public, and stand the test of time, which is a teaser from the bombshell piece of reporting that Professor Pearlstein just mentioned that Adam and his co-author Jodi Kantor released on Sunday. John Roberts' aspiration for the opinion, I think it falls very, very short. The decision in brief announces that ex-presidents are absolutely immune from criminal prosecution for official acts they take as president, even if those acts violate the law, if those acts are part of core presidential functions. And the court held that everything else that presidents do that also constitute official acts that are not core presidential functions are also at least presumptively immune from criminal prosecution. The opinion did allow that private conduct that presidents engage in while presidents are not shielded from later criminal exposure. But that wasn't really much of a compromise because no one at the point of the Supreme Court decision was arguing that private acts are shielded from later criminal liability. So there's a lot to say about the opinion, but because there's so much more to cover, I will just mention two things briefly. One, I find the opinion, and in particular the court's determination that discussions between the president and the Department of Justice are within that first category that I just mentioned, absolutely immune from criminal prosecution, both wildly wrong and absolutely chilling. But the other part of the opinion I want to mention is less flashy than the court's conclusions about presidential immunity, but really, really important. And that is a separate evidentiary holding that not only is the president immune for all of this conduct, speech and activities that fall within that first category of absolute immunity can't even be used as evidence in prosecutions that are allowable under the opinion. So it makes it extraordinarily difficult to bring charges, even for the most flagrant kinds of misconduct, against ex-presidents for things they did while in office. So the opinion has had already tremendous fallout. It has led Special Counsel Jack Smith to seek and then to get from a grand jury a new indictment pared down to remove allegations that this decision makes clear are off limits. There are briefs due next week about whether those new allegations survive this very exacting standard the Supreme Court handed down. And the court made clear that whatever the district court judge in that case determines is also going to be subject to another round of appellate review. And so this is a case that is going nowhere fast and by design, right? So that's the federal January 6th election subversion case. But the decision has also thrown into question the other prosecutions of former President Donald Trump, the Manhattan hush money payment case, even though it's about conduct that predates Trump's presidency, involved the introduction of some evidence that might run afoul of the prohibition that I mentioned, that evidence that pertains to official conduct may not be used even in prosecutions where the charged conduct itself is outside of the prohibition announced by the opinion. Likely similar arguments will be made in the Georgia election interference case. And a concurring opinion by Justice Thomas essentially gave rise to the dismissal of the other pending federal case against former President Trump involving classified documents at Mar-a-Lago. There, the case was thrown out not on the bounds that the conduct at issue was immune, but on the kind of antecedent argument that the entire appointment of special counsel Jack Smith was unconstitutional. That's something that wasn't argued in the case, but that Justice Thomas wrote a concurring opinion, kind of an essay arguing, and that was essentially adopted wholesale in this district court in the Mar-a-Lago document case. So that is my clear pick for the case of the term and some of the fallout we've already seen.
Okay, so I want to ask in just a minute, Adam, to tell us a little bit more about how he sees this. But before we do that, why don't we get the other, if we can I ask you just to talk about, right, that wasn't even the only case with Trump in the title, right? Or at least centrally involving Donald Trump in the court last term. There were a couple of other doozies, right?
Well, sure, actually, and if you dig deep, you'll see that a tremendous number of cases that the court heard had some connection to Trump, whether policies from his administration or things that are indirectly related to him, or even whether his name could be trademarked in a satirical, line of products. I mean, so it was really the Trump term in a lot of ways. But the other case, which is sort of the prequel before we get to The Empire Strikes Back, was called Trump versus Anderson. And this was a case from Colorado. And in this case, the Colorado Supreme Court had held by a 4-3 vote in December that Trump was disqualified from future office because he had engaged in insurrection against the United States. And that's a provision of the 14th Amendment that really there hasn't been much call to implement really in the past century plus. But Trump's actions did raise questions about whether he had run afoul of that clause. And there were efforts in several states to disqualify him from the ballot. And some people had been disqualified. There was a state official in New Mexico who was disqualified from being a county commissioner because he took part in the January 6th attack on the US Capitol. So in this Colorado case was the first one to get up to a level of a state Supreme Court and be ripe for review by the US Supreme Court. There are certain elements of Colorado law which made it one that rose to the top. And when that case matured, along with the Trump versus United States case, it seemed to, I guess to me a little bit, trying to speculate looking forward, that this was a perfect menu for the John Roberts that many people thought we knew, because he is someone who has said that he's very committed to the institution of the court, of not being identified with one political party and so forth. And here you had two cases where involving Trump and his activities related to January 6th and his eligibility for public office and what have you. And one, the law seemed probably in Trump's favor, and that was the disqualification case from Colorado. I mean, having each state determine whether a candidate was ineligible for trying to overthrow the United States could create some disarray in a national election. The other case, the law seemed by many lights pretty heavily in the favor of the special counsel, given the example we had with Watergate, given the pardon of President Nixon that he accepted, given, in fact, the memos by the Office of Legal Counsel, and even given the comments of Supreme Court Justice Brett Kavanaugh. When he was at a confirmation hearing, he was asked, this was in 2018 when there were some investigations of Trump going on, could a sitting president be prosecuted? And he said during his confirmation hearings that, the Office of Legal Counsel says you can't. And the question is really, can you prosecute a sitting president, or do you have to wait until he's out of office? And that answer to the question implied that that's the choice, out of office or in office, not at all, which turns out to be the secret third answer to that question. So it looked like John Roberts paddling one, the canoe on this side of the, paddling on one side of the canoe, then the other, might be able to bring the court, at least a strong majority, to one case, we side with President Trump. The other case, we side against President Trump, and we're not in anybody's pocket. We call the law as it seems. And actually, that outcome would have been consistent, I think, and professors can correct me, with the weight of legal opinion at the time, it seemed to me. But early on, there were suggestions that that's not the way it was going to play out. And one reason was while the court expedited Trump's appeal of the Colorado case, they very much slowed down Jack Smith's efforts to get the immunity question resolved. Although it was Trump appealing, the posture of the case meant that nothing could go forward until the Supreme Court acted on his claim of immunity. The court extended the term by a day to create an extra day to hear the argument, and really seemed to not feel this was an urgent matter that had to be answered immediately, unlike the Colorado case. And then the Colorado decision came out in March, and instead of being, it was a gimme. You had all 9 justices agreeing that one state can't take a presidential candidate off the ballot. Could have been a per curiam or under the chief's name or under Justice Alito's name or anyone's name, a 9-0 opinion that traditionally is seen to send a particular message to the country if the court is united. Instead, you had a divided court where 5 justices said, not only can Colorado not do it, there are all kinds of other entities that cannot take any steps to implement this insurrection clause. And that seems strange, because why go out of your way to answer hypothetical, speculative questions that haven't arisen at the cost of a unanimous decision now, when those questions didn't have to be answered? Leave it for another day if that arises. They could have done that. They didn't have to answer those questions the other way. They just didn't have to answer them. So that was a very important data point. Then we had the argument on the extended day of the term in April on Trump against the United States. And the questioning, the arguments seemed, as Adam's story highlighted, the questions were not about the actual verified facts that took place on January 6th or the related efforts. They were about extraordinarily surreal hypotheticals that have never happened in the United States, and there was no reason to think would or could, such as a future president bringing a criminal prosecution against his predecessor. And in most cases, if you're a former president, you're retired. I mean, there are very few instances of a former president sticking around. I mean, I guess John Adams joined the House of Representatives, but pretty much that's it. You know, it's not really a stepping stone. So prosecuting them for the way they implemented the border laws or whatever. And again, even practically, if you're a current president, why would you care? The guy's out of the game, you're moving forward. Anyway, the point is lots of hypotheticals about what might happen if you had a venal, horrible president and a corrupt, bad faith prosecutor hell-bent on exacting retribution against their defeated enemies or retired enemies. And that speculation, why? But that problem has been solved. The problem of what to do when a president might allegedly incite an effort to prevent the peaceful transfer of power, that question has not been resolved, but that's the one that we actually have. So I think it was a really interesting point, and as the story by Adam and Jody Kanner reveals, the Chief Justice drove that train very intently to reach the result he did, leading the dissenters to sign the dissenting opinion with a rarely seen send-off with fear for our democracy. I mean, that one, usually it's respectfully or something like that, right? But it's over, kids. I mean, like that, seeing that at the end of the dissent was kind of a surprise. So I don't know if that solves that.
I don't know if it solves anything, but it does tee up, sorry for Adam, a question. I mean, let me pose this in a somewhat, based on, sort of what we've just heard, a somewhat contrarian way, which is the story that we've just heard about the sort of Trump cases and the insurrection cases and so forth is, this is now a partisan court. This court, and your story has been read, right, by many to say, this court is just in bed with Donald Trump, right? It is the six and the majority at a minimum, including now Roberts, especially as we look toward this election cycle and the coming Supreme Court term, is a partisan court. So there's another way, and I'm going to put this out there and you tell me what you think, right? There's another way of looking at this term, which is these cases and the enormously consequential administrative law cases that the court also decided, and maybe you can remind us what those are as well, this past term, are not partisan as such. They're ideological in the sense that they reflect a long-held view by the conservative legal movement or these justices, right, that of something called unitary executive power, that the executive should have, right, a lot of power, should have control at some level. Is there a through line? Is there a way of reading these opinions consistently? Are they simply inconsistent, or is it neither here nor there? So I'll leave you with all of that. Good luck.
So I think you're inviting me to talk about some relatively boring stuff in the after.
It's boring.
But I take your point. There is a seeming tension between these two lines of cases. Let me first say a word about the Trump cases, and then I'll talk about the administrative law cases and address your question. Yeah. I mean, one thing that the story Jody and I wrote would seem to demonstrate, and both Kate and Jess have touched on this, but let me expand on it a little bit. We had one impression of John Roberts, and now we have another. We certainly had an impression of a relative moderate by the standards of Republican appointees, someone occasionally inclined to join the liberals, someone who saved the Affordable Care Act when it first arrived at the court, someone who staked out just 2 years ago a lonely position in the Dobbs abortion case, where he was the only justice who would have limited but not eliminated the constitutional right to abortion. And that represented, among other things, a real political savviness about how Dobbs would land, because had the Roberts approach been adopted and the court would have upheld a 15-year ban but gone no further, I don't think we would see the political cataclysm for Republicans that we saw with what Dobbs actually delivered. We also had the impression that, say what you will, John Roberts, very smart man, very good judicial craftsman, excellent writer. In fact, if you ask me, and maybe until recently, I would say Kagan and Roberts are the two finest writers on the court. The Trump immunity decision shatters all of that. And it was, among other things, both extreme and sloppy, cryptic, hard to follow. It delivered a short-term victory to Donald Trump for sure by pushing the trial past the election, but it left Judge Chutkan with impossible choices because what is this language? He has at least presumptive immunity for some conduct. Does that help us? Does that tell us anything? And okay, so that's a few thoughts on the Trump immunity case. On the question of how does the second set of cases interact with the first, let me lay out quickly 4 cases on administrative law. Don't go to sleep. The conservatives, Republicans have long been quite hostile to what they call the administrative state, to regulation. I would say to the concept of expertise. And that hostility is, of course, directed against the executive branch, but largely against so-called independent agencies, which don't always have the complete control of the president. So the court did 4 things this term. 3 of them by 6-3 majorities, with the Republican appointees in the majority, the Democratic appointees in dissent. The biggest one of them, a case called Loper-Bright, which overruled the foundational administrative law precedent, which said that in some cases, the tie goes to the administrative agency, where you have an ambiguous statute and you have a reasonable interpretation of that statute by an expert agency, whether it's on healthcare or the environment or consumer safety or the integrity of financial markets. In close cases, you defer to the expertise of the agency because they know it better than judges do, because judges don't know about parts per million. That's something you delegate to agencies. And of course, if it's easy and the statute says X, the answer is X. But if there's a gap filling function to be made by the agency under the Chevron doctrine, 40 years old, you defer to the agency. The Supreme Court overruled that. It was the big overruling of the term, as you had with affirmative action the term before and abortion the term before that. Big, big deal. How it plays out on the ground, we'll have to see, because the court left open the possibility of some kinds of congressional action. Just because you don't automatically defer to the agency doesn't mean you necessarily have to reject the agency's interpretation. It may well persuade you if you're a judge, but this will no doubt give rise to lots and lots and lots of challenges and will attack lots and lots of regulations. And then, for good measure, in a case called Corner Post, the court said, yeah, there's a 6-year statute of limitations. But that statute of limitations can be avoided if the challenger didn't exist before 6 years. If you create a little corporation that is subject to a regulation 20 years after the regulation's in force, that new entity, because it's subject to the law, the majority said, would suffer a fresh injury and can then sue. So you not only open the door on challenges to regulations, you also widen the time period in which those regulations can be challenged. And then a third case arose from a very common way for the Securities and Exchange Commission to try to address securities fraud, which is bringing actions in its own administrative tribunals as opposed to federal court. And that is challenged. The Fifth Circuit, where so much American law comes from these days, says that violates the Seventh Amendment right to a jury trial, that you can't be sued administratively inside an administrative tribunal. And the SEC is just one of maybe a score, maybe 25 of agencies that use these kinds of enforcement mechanisms. You have to go to federal court. That's an enormous complication and will result in fewer actions and less opportunity for regulators to regulate. Then finally, footnote, there are some propositions too crazy even for the Supreme Court. And again, I invoke the Fifth Circuit, which said that the way the Consumer Financial Protection Bureau was funded was unconstitutional. And the Supreme Court rejected that proposition by a 7-2 vote, with Clarence Thomas writing for the majority. And you know, if Clarence Thomas is reversing the Fifth Circuit has gone way wrong. So it's not that easy to harmonize these two lines of cases, because these are about executive power, and executive power is cut back and nominally shifted to Congress, but in fact shifted to the courts, because Congress is not going to do anything. And this makes the court the imperial body that gets to decide a whole range of not only the big constitutional social controversies, but also statutory regulatory controversies. And so I think that the takeaway, if there's a way the court is pro-presidential power, pro-presidential authority over agencies, but against agency power.
All right, that actually, that was a wonderful synthesis, all things considered, off the cuff, given the spot I put you in. But that actually tees up perfectly the question I want to pose to Josh, that'll put this in some political, we're in a policy school, not a law school. So I want to put this in some broader context, right? So one theory is, or the theory that Adam just offered is, yes, the court is pro-executive power, unquestionably, but centrally, it is pro its own power. And what we've seen this past term, and as we look ahead toward the next, is a consolidation of that power at a time when, thanks in part to your reporting and others, the ethics situation at the court is, I'll use the word, problematic. So maybe you could remind us just, briefly about some of what we know, but what, if anything, I think most folks know there've been ethics stories about the court, right? So what, if anything, did the court say or do or change, if anything, last term in response to this?
Right. So yeah, to give a super brief summary, there was a lot of reporting last year on ethical questions with the justices, particularly Clarence Thomas, who, among other things, accepted a really vast number of gifts, ranging from international luxury vacations to private school tuition, from a range of ultra wealthy men that he met after he joined the court, all in secret. And I think that raised controversy around a couple questions. First and foremost, was this all legal? And the short answer is no, but maybe not for the reasons you'd expect. So there's a landmark government ethics law passed after Watergate that requires most high-level government officials, including Supreme Court justices, to publicly disclose most gifts they receive. And many experts have said that Clarence Thomas had to disclose these gifts that he did not disclose. And Thomas has admitted in some instances, certainly not all of them, that he needed to disclose some of these things and has said he misunderstood the rules. But the more important thing, I think, is that under all the laws and rules that exist, Thomas was completely within his rights to accept all these gifts. There are still very few ethics rules for the justices even today, and essentially no rules on what sort of gifts they can accept and from whom, which is a remarkable anomaly in the federal government. Even Congress has far more stringent rules, to say nothing about a mid-level employee at the executive branch. And to turn to the fallout, perhaps later we could talk a little bit about what's been happening in Congress, but the court, of its own accord, in the face of this controversy last year, adopted and published a code of conduct for the first time in its history. This immediately attracted a wave of criticism, in part because it has no enforcement mechanism, and also it's a very lofty document, but it's very vague. And so absent an enforcement mechanism or some other form of oversight, it's not clear that this landmark change actually affected the status quo at all, where each justice is left to decide him or herself what is and is not appropriate conduct. That said, I mean, a code of conduct is a step that the court has resisted for a very, very long time, and it's possible that I think that it's indicative of a larger change in their attitude towards this issue, at least some of them, and that it could ultimately, I wouldn't hold my breath in the short term, prove the first step towards more robust reforms. Relatively recently, Kagan and Jackson have publicly expressed support or openness to having an enforcement mechanism for the code of conduct, which, correct me if I'm wrong, I think that's not a position a justice has publicly taken before. But on the other side of the coin, all this controversy has also led some justices to more clearly articulate a very different view of the matter. And Alito last year said in an interview that Congress has no authority to regulate the court, period. And he didn't fully explicate that position, but I mean, I think what that means is that there can be no ethics rules for the court that the court itself, the justices themselves don't voluntarily adopt. And seemingly is implying or saying that even the laws that do exist already, like the disclosure law I mentioned earlier, which can carry civil and criminal penalties, Alito seems to be saying that that's not binding and perhaps couldn't be enforced outside of impeachment. And so, I mean, the court changes very slowly. It's going to be interesting to see where this all goes from here. But to your original question, I mean, I think behind all of this are these much larger questions about the place of the court in society and its relationship to the other branches and to any mechanism that could provide some form of formal accountability and oversight. And this is made clear that there's serious disagreement within the court about those questions, but we haven't yet reached the point where this has come to an head and we have some sort of resolution and actually understand, is the court, this is a bit blasé, but above the law?
I don't think it's blasé, and that actually points in the right direction. Although the con law professor in me, I'm going to turn to Kate next. I'm sure she'd say the same, right? The con law professor in me now invites everybody to turn to, for example, Article 3 of the Constitution and the part, for example, where it talks about the court's jurisdiction being subject to such exceptions as Congress shall make, as a small caveat to Justice Alito's suggestion that Congress has no power to control the Supreme Court. But setting that aside for a minute, although, right, I mean, part of all the same discussion, Kate, what are we walking into this coming term? And we can start, there's a lot to cover and we will, we'll go around, but let me just ask you to start maybe with Adam's suggestion that the court has now opened the floodgates to any regulation that any regulatory agency in the US government has ever passed, SEC, FDA, EPA, take your pick, right, is now open for reconsideration and legal challenge in light of a whole new body of law, right? No?
So I would say yes and no. So the Corner Post case, the one that expands the time period that regulated entities have to bring challenges to regulations, does suggest we are going to see a massive uptick in the volume of challenges to regulations issued by agencies. I don't think there's any question about that. In terms of whether Loper-Bright kind of purports to say, well, we're not suggesting that every previous decision handed down under the Chevron regime, where courts deferred to agency interpretations of statutes, we're not saying all of those should be reopened, but it's not totally clear why. And it's not clear that the lower courts, maybe the Fifth Circuit in particular, are going to heed that. So I don't know that every single decision and every single regulation is going to be subject to a fresh attack, but I also don't think that the effort in the Loper-Bright opinion to tamp down those efforts is likely to be fully successful either. So I think those are kind of technical answers to the sort of volume of litigation kind of increase as a result of those opinions from last term. But I think there was kind of a broader vibe shift, I guess I would say, that those opinions suggest, which is just that arguments that challenge the authority of administrative agencies writ large are going to get a very receptive hearing at this Supreme Court. And I don't think there's any question about that. And if there was any question before last term, there's no question after last term. So there are already a couple of cases, environmental law cases in particular, the court has decided to hear this term. There's a case called City and County of San Francisco versus EPA about the Clean Water Act. There's a case called Seven County Infrastructure Coalition versus Eagle County about the National Environmental Policy Act, or NEPA. So these are two big environmental cases. The details are kind of in the weeds, but broad level challenges to the authority of agencies, in particular, I would say the EPA. In some ways, if you're, a regulator inside the EPA, you have to know that everything you do is going to be vulnerable. I actually had an interesting conversation on a panel with Nick Bagley, a law professor at Michigan, who I asked, coming out of this last term, what do you think an EPA regulator should do differently? How should they try to anticipate what the Supreme Court might do? And he said something I think very wise, which was that he said, I don't think they should do anything different because they're going to be vulnerable no matter what they do. So they have to regulate consistent with what they think the statutes passed by Congress mean. They should try to read the statutes the way they think Congress wrote the statutes, the way they think the words of the statutes are best understood, but they cannot try to look around every corner and anticipate every objection, because there will be new ones there'll be new iterations of ones we've seen and new ones we haven't even imagined yet. And so they just have to do their job of trying to implement the statutes passed by Congress, which by their terms and clearly were intended to protect our air and our water and our ability to live in health and safety conditions. But the Supreme Court is fundamentally, I think, hostile to that project. And that's a slightly different, that's a more existential disagreement than just the agency a little bit incorrectly interpreted whatever statute is at issue in the case. So those are a couple of cases already on deck. There is one bigger, so if Chevron was at the top of the list of kind of the deregulatory agenda, like toppling Chevron, that happened last term. I think the next item on the list is toppling another important Supreme Court precedent called Humphrey's Executor, which is a case from 1935 that basically blesses the constitutionality of independent agencies. And independent agencies, I should say, just to define for a minute, they take lots of different forms, but basically they're united by one thing, which is that they're somewhat insulated from total control by the president. And that's, with respect to the appointment process. The president doesn't just get to put, people that the president wants. There are constraints like a bipartisanship requirement, typically with a multi-member board, like the Securities and Exchange Commission or the Federal Election Commission or the Federal Trade Commission or the Consumer Financial Protection Bureau, or actually not the CFPB originally, but the Consumer Product Safety Commission. So these are all, agencies that have 3 or 5 or 7, directors or board members at the top, and the president is somewhat constrained in who he can, appoint to head those agencies, and importantly constrained in his ability to remove the heads of those agencies. And unitary executive enthusiasts, which Deborah referenced a few minutes ago, think that whole structure that I just described is fundamentally inconsistent with the right understanding of the president's power under the Constitution, which is the president gets to control everyone and everything in the executive branch, and these independent agencies don't align with that vision of presidential power, which is the correct vision of presidential power. So this opinion, Humphrey's Executor, has been somewhat whittled away at in a handful of recent Roberts Court decisions, but is still standing and still authorizes the existence of these really important independent agencies. And there's a pending petition filed by Don McGahn and others at the white shoe law firm Jones Day, with a lot, it's staffed by a bunch of former Trump administration officials, that basically says, okay, enough is enough. Overrule Humphrey's Executor, and basically, at least with respect to this one agency, which in this case is the Consumer Product Safety Commission, declare this structural feature of the agency unconstitutional. And how big that will be if it succeeds depends a lot on how the opinion is written. I mean, it could be narrow. It could sort of say that this particular agency exercises so much power without sufficient control by the president that it violates these core constitutional, kind of structural principles, but we're not going to say anything about other independent agencies or other agencies with a degree of independence. And in some ways, the kind of white whale here is the Fed, which has a degree of independence by design from presidential control. And an opinion in this case, if the court takes it and sides with the challengers, that is broad enough, could absolutely throw into question the constitutionality of the Fed. And if we think this court is already sort of revving its kind of destabilizing sort of the domestic affairs and the country's at least order, what it would do to sort of the global financial order for the Supreme Court to declare unconstitutional the Fed, I think cannot be overstated. And yet I think it's not inconceivable that we are on that path and that this term takes us significantly further down it.
Okay, so as long as we're in this sort of apocalyptic realm, we haven't even talked about guns and abortion yet. And given the most recent assassination attempt on the former president's life, the guns issue, right, exists actually at the intersection of agency, regulatory power, and the sort of broader conversation about social issues and social politics I want to turn to in just a minute. Can you start us down that road on the guns front at least?
So there are two strains of, excuse me. There are two strains of guns cases. One of them is constitutional. The Supreme Court revolutionized our understanding of the Second Amendment in 2008. And it said that you have an individual constitutional right to have guns, at least in your home, at least for self-defense. A couple of years ago, in a case called Bruen, it expanded that right to self-defense outside the home. And it also introduced a very novel, may I say, shocking way to judge whether all kinds of gun control measures are constitutional. Justice Thomas, writing for the majority, says what you have to do is to search old laws and see if there was something like that back in the day. And if there was something like that back in the day, then it's constitutional, and if not, not. Turning district court judges into historians, trying to figure out not only what the historical analogs were, but also how to make sense of whether something fits or not. Then so now we're in a weird new world of Second Amendment interpretation. Promptly, the court gets a case called Rahimi, which really tests whether this method works. Rahimi involves a federal statute that makes it a crime for people subject to domestic violence restraining orders to have guns. Some real miscreant named Zaki Rahimi, who has made a pastime out of shooting up, of threatening romantic partners, shooting up sites of road rage incidents. Once at a Whataburger? At a Whataburger, friend gets the wrong order, which happens at a Whataburger, and he discharges his weapon. So terrible, terrible set of facts. And the court, and this is, John Roberts doing somersaults to get there, said, yes, sure, we understand there was no such thing as a domestic violence restraining order at the founding when women were treated as chattel. Sure, we get that. But we're going to revise Bruen, at least in this regard, and say you could disarm people sometimes for being dangerous. Here, there's been an individual finding of dangerousness that the domestic violence restraining order provision survives. That's a slight cutback on Bruen, but it doesn't really tell us where we're going. And now we're going to have a flood of other cases, I predict. There's, at the argument, Justice Barrett suggested, and she's written on this when she was on the Seventh Circuit, that laws forbidding felons, including nonviolent felons, including people who committed tax fraud or lied to get food stamps, can be disarmed. Are those laws constitutional? Are laws addressing certain kinds of assault weapons and high-capacity magazines, are those constitutional? Are laws saying that you have to be 21, not 18, to have a gun? Are those constitutional? Barring guns from sensitive places, schools, churches, shopping malls, are those constitutional? So this Bruen enterprise has opened the floodgates in the constitutional realm, and we're going to see a lot of activity there. There's a second realm, statutory, where Congress may or may not have authorized agencies, again, we're back to this question of agency power, to regulate certain kinds of guns. This term that just concluded, the court said that the relevant law didn't reach bump stocks, which are a device that turns semi-automatic weapons into something resembling machine guns. Congress didn't write the law in a way that picks that up, even though Congress truly tried to ban machine guns. So bump stocks are okay. And in this coming term, and I think in the first sitting, in the first week of the first sitting, we're going to have a kind of, I'll call it a follow-on case on ghost guns. Ghost guns are guns that come in the mail in pieces and you assemble them yourself. And the question is, can those be regulated? Not even banned, but just to require that the manufacturers put serial numbers on them and do background checks as you do with any other weapon. And I think that case is a jump ball. There's some delicious briefing in there where the Solicitor General says, well, just because you get a sofa from IKEA and you have to put it together, it's still a sofa. And the other side goes, no, it's more like a taco kit where you have beef, but you have to grind it yourself, and that's enough different. So which metaphor governs may well give us the answer to that question.
So the age-old question, is a hot dog a sandwich, actually
Yes,
comes
right.
from the court. Okay, so I want to turn to some broader questions, but I just want to get at least two more buckets of what's coming down the pike on the table. So we had abortion to some extent last term with the mifepristone case, again in the regulatory context. Is it coming back this term? Josh, what do you think? Or abortion, and I should say, gender rights, broader questions in this realm more generally.
I mean, there certainly are major gender rights cases coming around gender affirming surgery for trans people. I mean, I think so far the kind of pro-life groups' efforts to kind of build off the victory of Dobbs have not been very successful at the court. The court has seemingly been reticent to kind of push the needle much further there. And it's been more in the political realm. It'll be really interesting to see if, to what extent the court has a similar reaction with the admin law cases as they did with Dobbs and to a lesser extent guns. I mean, it's because this is also the political consequences, as you said earlier, have become manifestly clear. I think a lot of analysts attribute the Democrats' surprising performance in the last midterm elections to Dobbs. And so, there's a lot of tension within the ground game, the activists and litigators that are actually pushing the needle on this. Between those who, kind of want to exercise caution and be patient with some of the decisions that, as Thomas pointed out in his concurrence, seem to naturally follow from the kind of underlying premise of Dobbs, which also would endanger Obergefell's gay rights decision and potentially case around contraception. And then there's another side of the movement that is like, that wants to go full steam ahead and kind of use this rubric to radically change the state of social rights in America.
Okay, so given those stakes, are we going to see in the actual election, right? I was looking, Mark Elias, who's a Democratic election attorney, but also just sort of tracks election litigation. With 50 days to go until election day, 49-ish, 48, where are we? There are 164 active voting cases pending in 37 different states. That's before the election, right? Is the court going to get an election case or two or more? Is the court going to be sort of right in the middle of this again?
Well, the court has said that in some ways it's not appropriate for the judiciary to get involved in political decisions. That's why they decided there was no federal constitutional remedy to partisan gerrymanders. It doesn't want to involve the judiciary in the political thicket. But it turns out that there are other areas of that thicket where the court feels quite comfortable, and that involves making decisions about actual elections that are in front of them right away. And the court has for certainly, for students here, for most of you, it was before you were born. For teachers and professors, maybe they remember it. There was a case versus Bush versus Gore in 2000, where the Supreme Court effectively decided who of two closely competing contenders was going to be president. And that was George W. Bush, the Republican candidate, who was ahead by 537 votes in the state of Florida. And the Supreme Court said, now it's time to stop the recount with Mr. Bush ahead. And since then, there have been many, many cases where questions of voting procedures and questions of voter registration rules and so on have come before the Supreme Court, and they have, in some instances, decided to intervene, and in other instances not. This year seems very likely that we will have a lot of election-related cases, probably the more interesting ones after the election, because there will be things probably in the run-up involving voting rules and so on, but when the 2020 election occurred, there were many, many changes to voting procedures due to the COVID pandemic and efforts by election officials to make it easier for people to vote at a time when public health authorities are trying to avoid large gatherings, avoid having people stand in line together, and so on. So there were a lot of accommodations then that reached the Supreme Court, and the Supreme Court intervened in some and not in others. This year, it is more back to normal, if America has a normal anymore, and we probably will not see as many cases involving changes to voting procedures shortly ahead of the election because of a public health emergency. But we have now though an attitude and understanding by election officials that perhaps they have more authority than they realize. That in past years, election officials saw themselves as having a ministerial function, like counting the number of electoral votes at a joint session of Congress or certifying the outcome of a precinct. Now, many of them believe and have been told that they have greater discretion to accept or reject the outcome of an election, the outcome of polling. And I think that election lawyers who are affiliated with the Republican and Democratic parties expect that, at least in some jurisdictions, perhaps the state of Georgia, perhaps others, there may be instances where local officials or state officials decline to certify an election result or certify an alternate election result, and that will lead to litigation and could reach the Supreme Court. So I think that really post-election litigation is going to be more significant perhaps than pre-election litigation.
So we'll have a panel here in this building next week, maybe Wednesday, I think. We'll send around an announcement about it that'll focus on particular election hazards, including litigation hazards, among others. But okay, so let me, we've got until 1:15, right? So great. So let me just now pose a question to the panel. And I want to be conscious too of the fact that the consensus seems substantially critical here. So I want to try to channel my inner Will Bode or some conservative legal scholars who would say, or who might say, right, okay, look, the picture that you've painted is one of a Supreme Court with significant legitimacy challenges, or what one might say. So query, is that the picture you've just painted, right? But really, what we're seeing is not that different from what we've seen in past eras of changes in political control of the court. So, in the New Deal era, right, we get finally FDR sort of gets his majority and then some on the court and begins overturning Lochner, overturning prior decisions, and upholding a bunch of liberal policies. Famously in the Warren Court era, we get Brown versus Board of Education in 1954 that overturns Plessy versus Ferguson and other consequential decisions. And this is not a fundamental legitimacy challenge, what we're looking at now to the court. This is cycles. This is the way it goes. This is the way it goes when effectively political control of the court changes. Okay, so thoughts, any piece of that? Does the court have a legitimacy problem? And is this something new, or is this, not?
But let me respond to the, is there something new, and others can address legitimacy.
Yeah.
I think there is something new. Until 2010, there was no closely divided court in American history where all of the nominees of one party were in the majority and all of the nominees of the other party were in dissent in the big cases. In 2010, they line up perfectly red and blue, and that's new. That's not to say there weren't closely divided courts before then ideologically, but now that they're divided along partisan lines, and now that we live in a world where there's no filibuster in the Senate, and that confirmation hearings are deeply politically divisive partisan exercises. I mean, recall that Scalia got onto the court by a unanimous vote. Ginsburg got onto the court with 3 votes against her. We're in a red-blue state where even something that you would think would be a wholly nonpartisan issue, like ethics reform, is deeply divided along partisan lines, where the Supreme Court's popularity, its public confidence levels in the court are deeply divided along partisan lines. And I think that moment in time happened in 2010 when Justice Stevens, a Republican appointee but a liberal, stepped down, and we all of a sudden had a court divided in a way that
Kagan's fault.
It's Kagan's, but yeah.
Can I just say, I think it's even more, I think it's Kavanaugh's replacing Kennedy, I would say, is because in 2018, because Kennedy was a Republican appointee who voted with the Democrats in hugely consequential cases. He not only voted with the majority, but wrote the majority opinions in all the big gay rights cases, marriage equality, striking down state prohibitions on same-sex sexual intimacy, invalidating state efforts to restrict anti-discrimination laws, protection of LGBT Coloradoans. So, that I think, until 2018, you did still have individuals appointed by a member of, a president of one party who mostly voted in ways that the other party preferred. So whether you, but I think it's right, either 2010, 2018, but in the relatively recent past, things, even if we had closely divided courts, even if we had, I think, real, kind of political shifts, they didn't track, exactly as Adam is saying, kind of partisanship and the preferences of the appointing president in the way we see today. So that is, I think, in the court that Deborah and I clerked on, you had Justice Stevens, you had Justice Kennedy, you had Justice O'Connor, retired just before I clerked, but who voted all the time with the liberals, so they were Republican appointees. And historically, you've had justices cross over in the other direction. Byron White was a John F. Kennedy appointee who was quite conservative, one of the two in lots of, not all areas, but many. He was one of the 2 dissenters in Roe versus Wade, though a Democratic appointee. And Roe, of course, was written by a Republican appointee. So partisanship did not predict judicial votes and opinions historically. And I think that's true even in the kind of post-New Deal era in 1937, when the justices start upholding a lot of the New Deal programs. That's still Republican appointees are in that majority. Roosevelt later has appointed 8 of 9 justices, but not right when they start the shift happens and they start upholding his opinion. So sorry to jump in, Adam, but I totally agree. I would just kind of pinpoint the time shift a little bit differently.
Okay, so the argument, this is new, this is different. Does this create a legitimacy problem? And if so, what does that mean? Right, I read a lot about Supreme Court legitimacy. I write a little bit about it too. But that term is used even in the course of sort of election discussion, and certainly in the course of discussion about elections. Does it have a legitimacy problem? And if so what, I suppose?
Well, Justice Kavanaugh was asked a similar question at a judicial conference in May. And he explained it that, I don't know if he used the term legitimacy, but he said that what's important for the court is that it has the respect of the losers. The winners are going to always be happy that they won, but the losers have to feel that the process was fair. And even if they're not happy with the outcome, they can understand it and accept it. And by those lights, if that's what legitimacy of a judicial institution has, remember, there's always going to be people are going to lose in a court case. That's just the way it goes. Then the court is having severe problems, because up until 2020, and this is shown in many surveys, including one sponsored by the National Academy of Sciences, the court had relative support from both Republicans and Democrats in the American population. And in tracking the court's ideology, it was somewhat to the right of the median American voter, but not extremely to the right. And in 2020, when Justice Ginsburg dies and is succeeded by Justice Barrett, the court's ideology, according to whatever objective trackers there may be, shifts much further to the right and becomes, and basically is identical to that of the typical Republican voter. And at the same time, the confidence that the court has among primarily Democrats and also independents or non-affiliated voters crashes. And so it has really become identified as a partisan entity by most Americans. So if that's, that's not spin, that is what, survey after survey shows about where the court is now. So in other words, what the court is doing in cases, and even this was true even before the Dobbs case, incidentally. This was occurring before before Roe versus Wade was overruled. You have decisions that that majority of the country does not have confidence in, and that is, I think, is it a problem for the court? I mean, I don't know. I mean, people still obey these decisions even if they don't respect them, and some people do respect them. So, how much of it is a problem? Does it matter? I mean, they have the power. They're there. The apparatus of government acknowledges and follows Supreme Court decisions, even if they think they are wrong. I mean, President Biden, trailing edge of the Democratic Party, endorsed some changes to the court's structure recently. Said had he profoundly disagreed with decisions like Trump versus U.S., but he's still going to follow them. I mean, even as he disagrees with them. So how much of it is a problem for the court? I don't know. How much of it is a problem for the country may be a different question.
Well, it's interesting, just as you were talking, I was about the compliance question, right? I was thinking, some of the most aggressive don't follow what the court says if we lose rhetoric that I've heard, at least in the last term, comes from the right. So the governor of Texas, who lost this case about the border control, right, essentially issues a proclamation that says, I don't know if I agree with that or I don't know if I care. Now, he didn't actually take action, but it was awfully in your face language from the governor of Texas. The current vice presidential candidate, J.D. Vance, had campaigned on actually, if the court goes against us post-election, my view is we shouldn't necessarily follow it. So I guess you're welcome to Josh opine on any of this, but let me ask in particular, given the stakes, how does this change how you as journalists, we as law professors, right, as professors in general, should this change how we talk about, report on, discuss the role and work of the court in the United States? I mean, your journalism has really been on the cutting edge of this in ways that have made a huge dent.
I mean, on the coverage question, I certainly think so. That obviously there is the the intellectual side of the jurisprudence, and that needs to be covered. But I think more and more, and over the last several years, we've seen the justices covered as being, part and parcel of a political system, even if not necessarily political actors, after they're confirmed to the court, which has kind of traditionally been when that sort of coverage stops, with notable exceptions kind of every decade or so for a long time. But I think to underscore one of the root causes behind what Kate and Adam were highlighting, this convergence now between the ideological and partisan makeup of the court. Something fundamental here is that that's not a coincidence. There's been a very concerted effort. We know more about it on the right. No doubt something's happening on the left, but they have been less relevant for a long time. But a concerted effort on the right to make Supreme Court nominees more predictable. Souter, who was a justice appointed by Bush Sr., the same justice that appointed Clarence Thomas, quite famously was very liberal when he was on the court, or rather liberal when he was on the court, and seemed to drift, as many justices do, to the kind of center left over the course of his tenure. This was regarded as a massive mistake, a massive missed opportunity, and there was hundreds of millions of dollars that have gone into an effort to prevent another Souter, and it's often discussed explicitly in those terms. And so we start to see turning points like, frankly, 2006, when Alito was picked to be on the court instead of Justice Ludig, who was a conservative lion on the appellate courts, and you now may know from TV, And then they've gone in very different directions in terms of their seeming commitments to
Harriet Myers.
Harriet Myers as well. And that was kind of when the conservative legal movement first really flexed its power in this, and it's become more so since. You know, the control, the predictability of the new justices, you know, might we don't really fully know yet. Of course, it's possible that Justice Barrett, for instance, turns out to have an independent streak that becomes the rallying cry of a new generation of activists. But you know, this is, you know, the ground game around this all has gotten a lot more sophisticated in the last few decades, and I think a lot of what we're seeing is the consequences of that.
I have just a quick gloss on that.
Yeah, and then I'll come back. Yeah, go ahead. Please go ahead.
And you know, we talked about the Loper Bright decision, which overruled a case called Chevron from 1984. That case, which turned over some more authority to regulatory agencies, was a victory for the Reagan administration. And at the time, like oil industry lawyers who had worked on that case told me they were unhappy that judges had too much discretion over interpreting the laws that affected agencies. And in fact, the Chevron decision overruled a DC Circuit case that future Justice Ginsburg had voted on against the Reagan EPA. And what we're seeing now, at the same time that this power is being returned to the federal judges, the same sort of interest that Josh mentioned about vetting Supreme Court nominees has been applied to vetting lower court nominees. So the federal bench today is much more conservative than it was in the 70s and 80s. And those judges who have been selected to the same type of process are going to be the ones ruling on agency decisions. So there's a sort of hand in glove aspect to it. The Supreme Court is part of the head of a larger branch, which has been remade as a result of political victories that the Republican Party has had.
So change how we report, change how we teach. Other thoughts about that? And Kate, I'm going to ask you, you're still teaching con law, right? I mean,
Not till spring, thankfully. Just yeah.
Okay.
But you haven't resigned from the
I have
enterprise.
not resigned.
You
from
have
the
not, right.
enterprise. Not yet.
Has it changed how you think about, right, so you and I both, to full disclosure, right, we both clerked for Justice Stevens, a Republican appointee. We clerked in very different terms, right, but I think had similar experiences, you know, even though some years back on the court, of not being the way the court is now. Does this change how you think about how you teach constitutional law?
I mean, I think all of us have probably taken a slightly more institutional turn in teaching. We're not just teaching doctrine. Maybe we were never just teaching doctrine, but we're also talking about the court as an institution, and in an institution embedded in, you know, political and sociocultural sort of systems, and that, you know, composed of individuals with tastes and preferences. And we probably all do that some. I think we probably all do that more. I don't think any of us just do that, because we still have to teach the rules that, you know, the court hands down, because you can't, as a young lawyer, show up to court and say, like, we all know who appointed you and how you're going to vote, right? You have to make arguments grounded in legal doctrine. So it hasn't fundamentally radically changed it. But can I say something just about the legitimacy sort of conversation? Just a couple of thoughts. I mean, I feel so conflicted about this, because coming into this election cycle, right, like, it could very well be that we have 2020 was, you know, a decisive enough Biden victory in enough states that the, you know, election subversion effort was always not just legally kind of baseless, but also pretty hopeless, because it would have required success in a bunch of different states. And we could well end up in 2024 with a closer election result where we really do look like Florida in 2000, or a single state or a single district in Nebraska is what the entire presidency comes down to. And it could be that the Supreme Court is the institution that has the final word. And, you know, what it will mean for our ability to accept a decision handed down by the court, that the court has shown itself, and I'm not saying this lightly, but it is to be an institution that we cannot necessarily, I'll cut the necessarily. I don't feel like we can trust the court to, in good faith, read the law and render a decision, you know, consistent with the best meaning of the law. And yet, we don't have a lot of other good choices in terms of institutions that can deliver a verdict on a question like who was actually elected president. And so, you know, I think that the court and the legitimacy crisis is an enormous democracy crisis. And I don't have a good answer. Do we need to shore up the legitimacy of the court so that we actually do have an institution that can hand down a decision we can live with? Well, not if they haven't earned it. And yet, completely deciding that this is a fatally flawed institution that we cannot trust leaves us without sort of, you know, an arbiter in a potentially really high stakes election crisis. So I don't have an easy answer to it. In some ways, I do think that part of what's so dispiriting about the John Roberts who emerges in Adam's most recent reporting is, someone who I would like in his best moments to be a steward of the court and the country that we can put faith in, maybe more than any other institution or individual. And I'm not sure we're there now, but we don't have another good candidate. So sorry, that's a really dark note to end on, but that's where I am, at least on this Tuesday afternoon.
Okay, so Adam, rescue us. You can have the last word. It can be dark or it cannot be dark, but right, I mean, it's a democracy challenge, and journalism is at the cutting edge of it, right? The Washington Post, says democracy dies in dark, right? How do you navigate this circle coming into or navigate these shoals coming into the election, or anything else you want to end on?
So let me do two things. One is, I remember Justice Breyer would walk around and saying, I was in dissent in Bush v. Gore. I thought Bush v. Gore was profoundly misguided, but I was delighted that that decision came down and there were not riots in the streets. People accepted it. We're now in an era where it's not as clear, and I agree with you that the threat would more likely come from the right. And we have seen an example, not of riots in the street, but of a full-blown insurrection. So it's hard to know what the public will do in response. The job of journalism, I think it's threefold. And it may be that over the years we've fallen down on two aspects of it. One is, it is important for journalists to tell the public what the Supreme Court has said in its decisions. That is not trivial. That you need to be able to translate to educated people the long, jargon-laden opinions and present them fairly, and in a way it's easier to cover than politics and climate change or whatever else, because there are good advocates on both sides, and you present their arguments fairly, and the public decides. There's a majority and a dissent, you present the arguments fairly, the public decides. But also, that journalism needs to be supplemented by the kind of look at ethics problems that Josh and his colleagues at ProPublica have done such fabulous work on. And we also should treat the court like any other organ of government and look inside its processes and see how it actually comes to decisions, and not take its word for what drove the decision if there's additional information to be found out by scrutinizing it the way we do the White House or the Pentagon. So if you do all three of those things, I think the American public will be aided in making its decisions, both on how to think about the court, but about, the fate of the nation.
Well, you actually did manage to end on a slightly better note. Please join me in thanking an extraordinary panel of journalists. We'll conclude here. We should leave the room so that the next class can come in. Thank you all.